It's just a minute past half-past, so we might make a start. I'm Deborah Scott, and I'm from the Law Society. I've been emailing all of you mercilessly over the last couple of weeks, and we'll be getting to know each other better over the next little while. I'm at a table here tonight with Angela Cornford-Scott, who's the chair of the Succession Committee, Rob Cumming and Michelle Sheehan, who are also on the committee, and they're here to answer your questions and work through the paper that was distributed last week. I'm here just to speak briefly about some of the nuts and bolts of the program and answer any questions you might have about that. If you have a question, would you mind waiting for the microphone? I'm not sure where it is, but there is one somewhere. Oh, okay. And either I'll bring it around or one of the girls will come in and bring it around. Now, this event's being recorded and will be posted on YouTube probably early next week. So if you feel you need to relive any of the moments, you can do it that way. Now, the take-home assignment is going to be released on the 24th of May. It'll be emailed to you. Yes, no sighing. Thank you. It'll be emailed to you on the 24th, and it'll go to your preferred email address, the one that we've been using up till now. I can't stress highly enough that you need to respond to that email when you see it. And it's really up to you to make sure that you get the email. I think the 24th is a Wednesday, so it's really important if you haven't got it by sort of mid-afternoon, if you just shoot me a quick email or give me a quick call. It could just be that we've got tied up with something else, but it will be definitely coming out on that day. So if you haven't received it, it'd be good to check that it's not something happening at your end that's caused that. Please pay close attention to the instructions that'll be written on the front page, or the front page or so. It's really important that you set the document out the way that we need it set out and also submit it in the way that we ask, and that facilitates the markers marking it, so it's very important that you do that. Now, the one thing I do also want to mention about that is that the document must be, or your assessment must be submitted by registered post or by hand, and we need one soft copy and one hard copy. So really what I'm talking about is a memory stick and a hard copy. And please no email submissions. We've had trouble with email, things not arriving because they're too big. You know, any problem with email seems to be particularly attracted to things that are date and time critical. So getting it here either by registered post, postmarked before 4 p.m. on the due date, or delivering it by hand to the front office here before 4 on the due date is the way to go. Your assignment won't be marked if it's submitted late unless it's covered or preceded by a valid special consideration application. So I'd suggest that you make yourself familiar with the special consideration requirements in the handbook. It's not the kind of thing you want to be reading about when you're already sick or in some other way indisposed and need a bit of space at the time when it's due. Now, the exam weekend is the 29th and 30th of July. Your oral assessments will be on Sunday the 30th at this stage. If you have a time preference, can you please let me know by email? What I'll try and do is accommodate people as best I can on a first come, first served basis. So if you've got a particular preference, if you can let me know. I'm going to assume that out-of-towners want a later appointment. That may not be correct. Something about talking in this room. Maybe it is that. So if you can let me know if you've got a time preference, that'd be great. Your exam will be on the Saturday morning, the 29th. It'll be an open book exam, 3 or 3.5 hours. I think that's right, isn't it? We're still, you're still still fine-tuning, but 3.5. You won't be allowed to bring any smart devices on the day, so smartphones, iPads, anything like that. You can bring a laptop in, but it won't be able to be connected to the internet, and in fact being connected to the internet is a reason for you to be asked to leave the exam room and not allowed to finish your piece of assessment, which will be fatal to your effort to become accredited this year. Please bring everything electronic that you want to use fully charged. We'll have some extension cords and power boards around the place, but we can't guarantee that everybody will be able to be plugged in all the time. So if you can plan to be self-sufficient, we'll support you as best we can, but we can't absolutely guarantee that you'll be able to be plugged in constantly. We'll be sending more details close to the time, and you can refer to the assessment criteria document for any details that you need in the meantime, any big picture details, or you can give me a call. In terms of the exam, I just want to talk through a few exam tips that I've collected from academics and former candidates and people to give you an idea about what you might want to think about. This is an open book exam, but it's really useful, I think, to prepare like it's a closed book. You're not going to have time to learn about things during the exam, it's fair to say. It's very, very time-intensive experience. So if you've got notes and things, have them organised so that you can use them quickly to jog your memory rather than thinking that you're going to have time to work through them. Practicing old exams under some time pressure is a great idea. If you've got access to the kit, it's good to take advantage of that. Deal with the hard stuff that you're studying as you're preparing. If you're finding something difficult, please don't put it aside, thinking that you're going to have the opportunity to get to it before July. I think we're looking at about the next 10 weeks or so of this process, and I think in some ways that time will go slowly and in some ways it'll go very fast. So be mindful if you've got something you need to do, now's a really good time to get it done rather than putting it aside. The old famous exam technique about using your time wisely, understand the marks that are available, understand the time that's available, and understand how you want to relate those two things to each other and make a plan and stick to it. Read the question and answer the question. I think that's a very good piece of exam advice that I'm sure we've all gone wrong on. It's not a bad idea maybe to have some set bits and pieces in mind that you might want to write about particular issues, but that won't take you the whole way to answering an exam question. So you have to be prepared to be flexible and answer the question in front of you. And if you have messy writing, write on every second line. I'm pretty sure that's how I got through university, as a messy writer. So, and it also makes it easier for the markers to do that.
And try to make it somehow legible, because if you can't read it, it's very hard to mark it.
Yes. And just make a plan and try not to panic. If things don't go quite according to plan, just revisit the plan. I'm going to hand over to the committee in a moment, but just before I do, I just want to say that this is going to be a really tough little time for a lot of you. It's a lot of work, it's a lot of study, it's a lot of pressure. Your assignments coming, you've got your businesses, your practices, lots of things on. As members, you've got access to the services of law care, and I'd really urge you to consider, if you're feeling overwhelmed or if you're struggling with how to get some perspective and manage what you're doing, to consider using that service. They do provide a great service and it's available for you if you need it, so please don't hesitate to take advantage of that if you need to. And with that, I might hand over to the committee to talk about the question and whatever else they want to talk about. Thank you.
Thanks, Deborah. I might just check if anyone has any questions of Deborah before we move on to the actual problem. No? Okay. So you should have in front of you a copy of these two questions that came from a past exam. So what we thought we'd really do today was, hopefully you've all had the opportunity to read it. We thought we'd take this time to really work through it and to find out how to structure it, how you would spend your time in relation to that, and then obviously we'll talk about some of the issues themselves that are involved in the problem. When I looked at this question, structuring can be quite critical. I think it's fair to say in some of the questions that you get both in the take-home assignment and the exam, because the questions are meaty and they're designed to be meaty. So that means that there are numerous issues in those questions. And one of the things that we certainly have recommended in the past is, as you're reading through the question, you might jot down the issues, and then as you read it the next time, you might jot down the other issues that jump out to you at that point in time. And that in itself will start to form a structure for how you might actually answer the question and address the problem. These two questions are quite well structured for you already, because it's very specific, the answers that are being requested of you. But Deborah made the point, answer the question. Remember to actually read it. I tell my children this all the time. Read the question and make sure you answer the question, not what you think the question actually might say. So that's really important, just to, when you've got that, adrenaline rush and you're racing through, just remember to be careful and check that you're actually responding to what the question is.
Just a quick question. Has anyone gone through this and attempted to write an answer under exam conditions, such as, I think for this question it'd be 45 minutes out of the paper. Has anyone tried to answer that question in 45 minutes? Well,
Rob was going to make you do it now.
That's right. Well, we go while we go and have a drink. No, not at all. I'm probably getting away from it, but on past experience, even as recently as the last time round, candidates failed to answer all questions because they simply ran out of time. So I can't stress that enough, that you need to be rigorous with your time. So maybe if you're preparing, not necessarily this question, if you have if you've got the kit for the previous exam questions, force yourself to answer it under those time pressures, because it's going to be too late when you've got 5 minutes to do one question or something like that. So I just stress that. So anyway, we'll move on to, unless there are any questions, or Michelle's got anything to say.
Only on the timing issue. One tip is not to get bogged down on one particular part of a question. So if you look at the structure of this question, you can see how the marks are allocated. So it is not going to be helpful for you if you're bogged down on the 8 marks in task 1 and then have to rush over task 2 and 3. If you find yourself doing that, if you can then try to pull yourself up and then move on, even if you have to come back to finish.
How much can we write?
Sorry.
I'm sorry. How much are we can we write in like dot point form, as opposed to full sentences all the time?
I think we're fairly flexible on that, so long as we can understand what you're actually saying. I think whether it's dot point or whether it's full sentence structure, so long as it's clear, it'll be okay.
So it could be something like, they'll take into account A, B, C, reference, case, da da da. Mm-hmm. You can do that if you would. That's okay.
Yeah. So I think the most important thing is the reasoning. Would you agree with that? It's the practical reasoning and the application of the problem. But definitely reference the issue in the case. You don't have to go into chapter and verse, as Angela explained.
And you don't need to repeat what's in the question either. I think we've seen that mistake of people in the past who spent time repeating what's in the question and then have obviously run out of time in doing, what's really the critical part is the reasoning and working through the actual problems.
I mean, ideally, if you can structure it like an essay, that's great, but at the end of the day, we're looking for the substance of your analysis of the problem, your identification of the issues and your solutions for dealing with those issues. And if it's, as you say, the points to consider consider well, as you outlined, Sarah, then that's, that your knowledge comes out that way.
And I will just clarify, that's the exam we're talking about. It's certainly not the expectation in relation to the take-home assignment. And I might just make the comment, Deborah, to add in relation to the take-home assignment, marks are allocated for drafting and errors. So if you hand in something that is full of typographical errors, that will impact upon your marks. You do have the time to check it. We expect you to check it. We expect you to produce something that you would be comfortable to send out with your name on it. So those things are all very relevant.
And just on the take-home exam, take-home assignment, I should say, while there's not the time pressure other than you've got to hand it in by the due date, there is a page limit, so that structure you have to be precise in answering the question. Yes,
Yes.
Juanita?
Thank you. Between now and the exam, will we get a confirmation of how many questions there are in what parts and what marks they're worth, so we can plan our time allocation before then?
I think
Yes.
I can. Yeah,
Deborah's nodding, yes, you will.
Yeah.
Thank you.
All right, so if we head into the questions, so if we look at part A first. Is anyone prepared to first of all talk about, so if we concentrate on task one, the issue at hand in task one, does anyone want to start the conversation about where you might start to draft your answer here?
I guess
Anita?
as far as drafting, perhaps identifying some dot points of what the specific issues are with each subset there, for example, stepchild or size, then list some cases to support that are relevant to that section or relevant to that topic, and I guess pull some comments hopefully from those cases.
Yes, that's right. So you would start clearly with the jurisdictional questions, and so I guess for question one we're looking at, well, a stepchild is going to be eligible, so we'd expect you to go through those basic jurisdictional issues, at least at a basic level, to show that you can tick those boxes. Don't expect you necessarily to write quotes out of Singer and Berghaus or anything like that, but nonetheless to be able to show those critical issues. Any other thoughts? Any thoughts about cases, how you might actually use the cases when you're answering a question?
I think that when you're answering these, if you can, would it be right to say that you'd say perhaps in this particular case, the court said which was about a stepchild, the court took this approach. However, but in this case, the court's taken this approach. So generally, the courts have said X, Y, Z about stepchildren and the claims that they have on the estate.
Yeah.
And I'm just looking at that. Would it be right to say, okay, I'm looking at that task one's divided into 4 subparts, total of 8 marks each. Would it be right to sort of say you'd be looking at about 2 marks per question there?
Yeah.
Normally, it's exactly how we would think, and so that's exactly how you could think in relation to the allocation of those marks.
Okay.
It's much more difficult, of course, when you've got one big question, which will just say down the bottom 25 marks. You've got no idea how it's spread throughout that question, and there will be a number of those questions on the exam.
And the reasoning behind setting those questions is because we need to test your ability to identify some of these very important issues. And then once the main issue is identified by you, that will flow through to the other issues that will follow, if that makes sense. So it would be inappropriate to lead you right to that main issue we're trying to test you on.
Michelle, am I right in thinking that these questions are obviously designed to have you pick up perhaps more, subtle complexities in the questions, but would it be a mistake to ignore real basics in answering questions like this? Like Angela just mentioned, that talk about the jurisdictional issue first, about eligibility, which probably is a fundamental basic. Would have been a meatier, bigger question like Part B on this, which is worth 10 marks. Would it be a mistake to jump right into the complexity and miss the
I think
real
so.
basics?
I think you need to start
the
with
fundamentals?
the basics and then go through to the complex issues. We have a practice which, this is my first year on this committee, so I defer to Angela and Robert. But I in setting these exams, I know that when we don't want you to get sidetracked on an issue, we will actually state that in the question. So,
If it's an obvious issue, so sometimes you'll have some guidance in there.
okay.
But there will be some questions where you could inadvertently go on the wrong track, and we won't necessarily address that, point that out to you. Back to your question about those basics, Michelle's absolutely right. Don't ignore the basics. The issue is how much time you spend on the basics.
Right.
So if you know that the real issue is this level of complexity down here, then you need to make sure that whilst you address the basics, you address it appropriately in context of the
Very
size.
quick.
Does that make sense?
And that's where you might be able to do a quick bullet point. Yeah.
For instance, if it was a question about family provision applications, and the question is, how would you advise the client? Well, you wouldn't miss out the time limit issue or something like that. That's fairly basic, but you wouldn't miss that out, and then you'd go on to the media issues about the moral obligation, etc., and how that might be dealt with.
So you can see if these questions are worth 2 marks each, they're going to be pretty quick. You're going to try and deal with them really quickly in the context of the time that's allocated to you for the whole exam.
So if we take,
Sorry, I do have one more question.
I was just going to comment on that. So if you reference back what we're testing to your case reading list or your reading list, and you're able to sort of put that in a way that you can access it quickly, you should be able to pull out from what you bring with you really quickly some of these fairly major points, and then the test is the application or your understanding to the facts. So there's nothing here that many of you wouldn't know and really isn't sort of part of your everyday work, if that makes sense. Don't fall into the trap of thinking everything's going to be highly technical and difficult, because it may not be. It may be quite straightforward.
Don't have another question.
Yeah. So moving on through this question, items 3 and 4, is there any thoughts about what you might comment on? We could do 2, if you like.
Sorry.
2, 3 or 4. Anyone got any thoughts? Thanks, Michelle.
Just on 3,
I would sort of consider pointing out the court's consideration of certain disclosure or lack of disclosure in parties to proceedings, and the weight or lack thereof that is applied to the lack of information and the whole of the assessment of a matter of a family provision claim. With you know, obviously the cases that have maybe commented on that very thing of where there's no disclosure, then technically they can't consider the whole of the facts. So there's going to be a number of assumptions or just pure no consideration, which could impact on the overall outcome kind of approach. Would that be the kind of thing you'd be looking for in that answer?
Yeah, absolutely. Anyone got some thoughts on the final point of that question?
I was just going to add to what Michelle said. I think it would also indicate that he may not have a need if he doesn't put his financial position in, so that the court may presume that there's no need to be presented as a competing beneficiary.
The other thing that you may need to think about in some of these issues is, what's your obligation here? Are there professional issues that you might need to make reference to as well? The next part of the question. Rule 700 capital A, has anyone got any thoughts on that one? Everyone know what Rule 700A is? All right, why don't we keep going through the question? Task 2, the problems that you may face and your obligations to the court. So what do you think we're looking for here?
Full and frank disclosure is the first thing that comes to my mind, and perhaps having to put that to the client so that you can provide not only the advice but the potential outcome and assessment of the outcome from there.
Any other thoughts?
One point I thought about was the potential for a conflict between the two clients. We've got two executors, Mark, who's been rather difficult, and I think the other had indicated she'd be willing to settle for an amount. So just the potential for a conflict between our own clients and what we need to do there.
Yeah, absolutely.
So if you were structuring this answer, is there a way you might think of looking at the different conflicts and just structuring the marks around that? Would anyone have a suggestion on that? Or different duties and obligations, wearing different hats?
Do you mean, the conflict between your client and the court, and the conflict between your clients?
Yes, so you could look at your duty to the court, you could look at the conflict between the clients, and then you could look at the solicitor's duties and obligations. So you see how whilst the question might be worth 4 marks, you can even break that up into a way which will then allow you to sort of identify further issues under each of those headings, or provide some reasoning or information under each of those headings.
So all of those 3 points that were made are all points that we would expect to be covered in this, and we would expect you to look then at your professional obligations under the conduct rules as part of that as well. So just to give you an idea of the breadth. So again, there's not a lot of marks in that, but you can still see within that what's there. What about task 3?
So this to me is a really good example of how all we're asking you to do is to address something that most of you would do in everyday practice. We just want you to put it on the paper.
And we all, we all deal with difficult clients or clients who don't want to take our advice. So and you can see clearly this question is asking for your thoughts about how do you deal with that situation? What are the solutions that you can come up with?
So I'm thinking 3 marks are correct to come up with 3 things. So perhaps one would be earlier without prejudice offer of settlement to the other party.
Yep, that's right.
Perhaps a teleconference without your clients involved with the other solicitor to try and get to the bottom of things. That seemed to be what blew it up in the first place.
And then perhaps if you drill down on that, so one of the things you'd be talking to the other solicitor about might be information you need so you can go back to your client. So you're asking for informal disclosure. So, it's just putting you back in the chair at your office and you writing down on paper, okay, well, what do I do when I'm in this situation? Okay, well, I might pick up the phone and ring someone. What do I need? I need to resolve this matter early. We need all the information we can possibly get. Then think, okay, what else could you do if you're not getting that cooperation from the other solicitor? What do you do? Every one of you would know what to do. What do you do now if you're not getting that cooperation? Maybe you go to court for a direction on disclosure.
Or bring on your directions under the Family Provision Application.
See, so, and then, what Angela said before, that's not something that's a real legal issue, but it's managing your client's expectations when you're dealing with a difficult client.
Isn't the problem our client is not disclosing?
Yes.
As opposed to...
Oh, look, I'm only talking.
Oh, right.
Oh, okay, sorry. I'm just trying to put you in a spot where, of course, you've got to know your cases and do your reading and do everything that, need to know what you're doing and understand. But a lot of what we're testing is things that we would be expecting you're addressing in everyday practice.
So yes, Sarah, so when you're managing your client's expectation, if they're being difficult, you can say how that might play out in the conduct of the case, how that might affect the ongoing settlement negotiations, etc. And just talk about that, what's, the whole settlement thing, we've talked about the informal nature of it, and then you'd probably have to talk about then whether if that doesn't work, then obviously you have to go through to the mediation stage under the directions order.
Is there any other thoughts or comments about that question?
The other point I had was advising the client about the prospects and what the possible or likely outcomes might be. Sometimes they don't appreciate or understand it until they've got something in paper in front of them. To have a look at what the likely costs are going to be for the matter to continue on to mediation or to trial, compared to what a reasonable offer might be and the difference between those two figures. So I don't know whether that was something you'd be looking for in that sort of question.
The reality check is what we call it. That's right.
I think that comes back to what Michelle was talking about, managing your client's expectations.
I call it readjusting their expectations. And sometimes you can get halfway through a matter before that kind of finally clicks that
that happen.
And part of the answer that we expect out of this is addressing and managing that your client's expectations. So again, it's not necessarily a legal issue, but it's an issue that we expect as specialists you would be able to handle and deal with. And that does involve, being very clear with the client, but it also involves you being very direct with the client about what their obligations are. And you then have to understand your professional obligations and where that line is, and where the point is that you can't act, and where the point is where you're getting close to making that decision.
So when you are looking at that question and what we're seeking from you like that, do you see what we mean when I say it's not conceptually difficult, in the sense of it's something you would all be doing in practice every day? It's just recognising that it needs to go down as part of your answer.
And you've got a million things travelling through your mind and you're trying to get them down. So.
Including lack of sleep and nerves, which apparently is like going on having a few drinks. No, it's not the fun way to do it.
Sometimes you do have reading time before you actually start the exam, so you can go through and read through the questions. And it's been a long time since I've done the exam, so I'm useless at giving you any tips. But back in the day that I remember doing the exam, one tip I was given, which was always good, and we certainly have talked about this, pick the one that you feel comfortable with first. Give yourself a bit of confidence. Don't go for the hard one first. Get the confidence up, and then you'll feel like you've got a bit of momentum. So try to focus on those. A lot of the time we'll have short answer questions. That might give you a bit of confidence if you feel like you can go through and answer those quickly and you've got that momentum. So try and look at the whole exam and approach it from that perspective. Are you happy to move on to the next part of the question? So what are we looking at predominantly here to start with? What's the focus of the answer? I guess,
Sorry, just taking it from the start. So the elements of what an estrangement might constitute, and the role of the deceased in that estrangement, the sort of thing you mean?
I'm actually going back one step. It's the likely approach of the court in Queensland is the first thing to look at there, because there's been different responses in different jurisdictions to some of these issues. So again, I'm just trying to highlight to you, that focus that's important. But you're exactly right. Moving on from that, the estrangement issue.
So, Angela, it'd be correct to say we wouldn't be expecting you to do a treatise on what every jurisdiction is going, how it might look, and an estrangement might look in different states.
And if you really like Master Sanderson's judgments, it probably is not really what we're looking for, because they're not Queensland decisions. So again, I'm just trying to get you to focus on the question. So moving down from there then, some thoughts.
So the question directs you to what's the approach the court's going to take to an application by a stepchild, and there are a number of factors that arise on a particular encapsulated in the dot points at the end. So I suppose in dealing with the application by a stepchild, these factors arise, how that would likely be dealt with by the court, and then you can put your points down about those particular issues and quoting cases where appropriate. So what are some of the things that you might deal with on each of those issues?
Let's look at estrangement particularly first of all. So what are the sorts of things that the courts look at in estrangement?
The cause of the estrangement, if there's been any attempts to rectify the relationship by either party during the lifetime of the deceased.
Yeah, that's right. Michelle, did you do something to that?
Yeah, just to touch on that very same thing. So, sometimes the extent of the estrangement, how many years, etc. What was the cause of it initially? The attempts that either party have made to reconcile. The aspects of family members or other parties around the deceased, and in particular the applicant, in terms of the general assessment of the estrangement between parties and that kind of thing. So just really adding to Juanita's comments before.
So looking at these facts, does anyone want to have a go? What might be the attitude of the court on these facts?
Just that the cause of the estrangement doesn't really seem to have been by Alex. He was isolated from his father. Well, the divorce, the fact of the divorce between his parents, the deceased and his mother, and the fact that from a young age he wasn't given the opportunity to establish a relationship with his father. It says here that he tried to then establish a relationship when he was older, but geographical distance made that difficult. I would say that overall the court probably wouldn't place a large amount of weight on the fact of the estrangement and assessing Alex's claim, purely because it doesn't really seem to have been from Alex's end that he was estranged from his father.
Thank you. Any other comments?
Just to add to that, I suppose, with the estrangement, it's generally a high threshold to meet in any event, from what I've gathered over the years. So I think it would very much be a matter of cause and whether they can really dislodge that or to uphold it. There was a pure estrangement that then caused it to be a complete failure. But I agree with Chris in that regard. It would be I think the court would certainly not put as much weight perhaps as the executors would hope on that kind of estrangement in that case.
And that probably goes to the basic issue you might mean, is estrangement of itself enough to extinguish a claim? So you make that basic point that depending on the circumstances, it's, as you were just saying, Michelle, it's the weight that's placed on the estrangement, not that it's once estranged, that defeats your claim.
Would you make the point as well that the deceased doesn't appear to have actually tried to establish a relationship with him at all as well?
Yeah.
It's not just his fault that maybe he didn't, he's the cause of the estrangement.
That's right. Well, that's relevant to, that whole wasn't his fault to start with, and then there's been no effort subsequently to change that.
But just the discussion here is another example of how you jump in at the estrangement, but the basic point is he must show a need. So if he shows the need, it's then the issue of, well, how does that estrangement impact upon the need? And the greater the need, the less likely the estrangement is going to play out on that. Can you see how you bring the basic in, but the issue is the estrangement?
How would you be expected to answer that in this particular question when you're talking about the court what would the court consider in relation to the estrangement? Would you then be expected to address his need and the estrangement. Is that what you're saying?
Well, he has to have a need. So here, it seems on the facts he has a need. So when you look at the degree of his need and balance that off with the types of things that have caused the estrangement, so all the things that have been discussed and the issues identified in the room are matters that you would address. Yes, Cliff?
Just a comment, and only because it was Angela who raised Master Sanderson. But there is an estrangement and more likely disentitling conduct case of his from last year, where the fellow was in extreme need, but the level of the estrangement and conduct was sufficient to reverse it, as in he didn't get anything. So I would expect that that's as far as there's a need, but his estrangement isn't sufficient to, on those facts, to override it, and then just keep moving because it's only
That 2 points?
yeah, it's only 2 points.
Yeah.
More importantly is the other elements to get the rest of the points.
That's,
So
yeah. But
provisions in the will, in
but-
terrorium doesn't.
in that 2 points,
You've
so
got to raise name.
you need estrangement and then the discussion of estrangement, which, so that 2 points is a meaty 2 points.
Mm.
Is that a fair comment?
Yes, yeah. But everything that you said, is correct in what's relevant to that consideration of estrangement and how you've then applied it to the facts of this case. Now, as we know, law proceeds on the basis that there's always more than one way to think. So, it's not necessarily that there'll be a right or a wrong answer, it's the way you reason it and come up with what your view is.
Just following on from what Cliff said, in the way that you would answer a question like this, though, because it says what would the likely approach of the court in Queensland be, would it be, we're in an exam, we're pressed for time, is it, are you going to get any bonus marks for referencing a Western Australia case in a case like this? Oh, no, it made me think of then, okay, well in a question like this, Cliff, I just meant that then made me lead to this question, like, is that a wasted effort basically in a question like this?
Yes.
Because you're pressed for time.
Yeah, and we're not looking for it.
Okay. We're not in the habit of delivering bonus marks, if I can put it that way.
Yeah. So you wouldn't say, even though it says in Queensland, it really would be a waste to say the Queensland court approach has been this, as a by the by in Western Australia, they've done this recently, that's just complete in this question, waste of time.
That's
okay.
There are Queensland cases, I just can't remember the name.
Oh, no, I just meant your comment made me then think of how to answer this question.
That's a good question.
Okay.
And, there's so many issues in the questions that for you to just address those issues is all we can really expect you to do. So if you do feel in a flight of fancy that, I've got this flurry of, independent
but I have all this knowledge, Angela. I want to put it all.
We know you have lots of knowledge, but it might be a waste of your time to actually spend time writing it down for us. Does that make sense?
Yeah.
Yes, exactly. Spending 15 minutes doing a brilliant answer on estrangement for 2 marks, and then you run out of time to answer the other part is a waste of effort, probably.
Could you assume that, so there's 5 points there, 10 marks. Do you need to, is it a point for the point and a point for the case?
No. It's not necessarily
Right,
that strict.
Yeah.
All right, so move on to the provisions of the deceased will.
The interrorium, forgive my pronunciation, the interrorium clause has no effect. Courts won't apply, and there's at least 2 or 3 cases to drop at the end of that. Then the statement by the father is, I'll get this wrong, it's admissible as evidence of his state of mind, but not as to the truth of the fact that he hadn't tried to contact or he's irresponsible with money.
That's exactly right. Any other thoughts?
So the expectation would be to refer to the Evidence Act provisions. So you don't have to write out the whole section. That again is just a waste of time, but to identify a particular section.
It's got really cold. It's not just me. We're not trying to keep you awake deliberately. All right, so inheritance Alex received from his mother.
Looking at his needs at the time of father's death in the application, he has received something previously, but would be the same if he'd won the lotto or something else had happened. So he's had a divorce, unless they're going to really try and draw out his problems with financial record in the next one. It's an issue, but it's not really a major issue.
Yep. Other thoughts?
I thought the court would consider the fact that his two siblings didn't receive anything from the mother's estate, just as a comparison between their competing needs.
That's right. It certainly has some level of weight in that comparison. Any other thoughts? Anyone want to have a guess as to how much weight might be given to that by the court? And I do mean a guess because who would know?
I would have thought it wouldn't have made a huge amount of difference because they're both pretty comfortable anyway. If they'd received an equal third, it probably wouldn't have made a huge difference to their financial circumstances.
And when you're making that assessment, what are the concepts that you're thinking of there? Sorry, Hayley, to put you on the spot.
Just comparing the financial circumstances of the three siblings, I think the other two were reasonably comfortable and able to provide for their lifestyles out of the resources that they already have. If they had received anything from their mother's estate, it probably wouldn't have made a huge difference because to them it's a relatively small amount. Whereas Alex's circumstances, he's not that well off. It probably would have supported him a lot more to a greater extent than it did the other two.
That's good. All right, well, we move on to Alex's poor financial record.
I'm thinking probably relevant is Cliff's comment before that it's still his need at the point of time of the application. it may be more relevant to the form of provision that he's awarded. So if he is historically very bad with money, it may be that it's best awarded to him in a trust rather than an outright legacy, or not legacy, an outright award of money.
Yeah, that's exactly right.
We're not told, as far as I can see on my scan, but I'd raise that it appears because of that poor financial record, he doesn't have a house to live in. The other two have houses and they have incomes. So whether or not that's part of the structuring it's part of the overall answer as to his need as well. But this is probably a time to raise it. So that, yes, and there's a quote somewhere that I've read in the last 2 or 3 months about sometimes wood ducks and lame ducks are just like that, and they get something, and if they waste it, they waste it.
That's right, that's a good point, because it's also looking at what's the court's attitude if someone, isn't good with money. Does that mean that their need is affected and the provision is affected?
Wasn't that was a stat law case, I think, wasn't it? When they were looking at maybe, sorry.
I just remember highlighting it, but I haven't gone back and found it. Actually, New South Wales that will case was declined, and it was actually the son about to go bankrupt that was making the application. It was.
Wasn't it the one that in his car?
That might have been part of it. Yeah. It's a recently declined New South Wales stat will case.
Would it go to questions of moral obligation? The father said in the will that he was bad with money. He's acknowledged it in a form, but didn't provide for him, knowing that he was potentially someone who morally should be looked after.
Yeah, that's right. That's a good point.
Not a direct use of the wording, but.
Just finish off the last dot point then.
Move on to the last one. So, Alex's support of his children.
They've got a need. He's not directly required to support them, but he does when he can. So the need isn't as great. I mean, that's not an argument in his favour, but it's not necessarily something that bears heavily on the question.
I'd also point out that one of those are a minor child as well, so there's that level of dependency. A 10-year-old, even though again he gives them money where he can, but from a parental responsibility perspective, it goes to need in that respect, being a dependent child. Notwithstanding, he may not actually give much or as much as he should perhaps, but it's certainly an element I'd put down.
What sort of elements do we generally look at for need?
Shelter, clothing, housing, supporting the minor children, as Michelle mentioned. So the basic needs without being extravagant. And comparing that to, as I mentioned earlier, the other two have houses and an income. And at least the sister may be getting some support as well. And they're being supported by their adult children, whereas he's minor children to support himself.
Probably also adding to that prospects of employment in the future, depending on their age, and also any medical needs. So if they needed ongoing medical care or had a very major sickness or illness.
That's right. That's right.
And just on that, so in the way that you would respond, would you be pointing out the elements of how adequacy has been determined as it relates to an adult child, where there is a level of dependency of a minor child at least, and sort of backing up with appropriate authority, again for 2 marks worth, but just touching on how adequacy messy as a word, you know, and what that actually entails, you know, the cheese and jam and all that kind of stuff. But as it applies to the adult child, would you go into that kind of thing, or just, again, practically not so much?
Probably the cheese and jam comment.
Cream and jam.
Cream and jam is probably not where I'd head with it. I think I'd be more looking at, well, when considering this in the context of his need, you know, this is a relevant factor, as is, you know, these other points. This is a relevant factor here where there's a level of dependency because it's a responsibility, and probably I'd come at it from that perspective.
Yeah, thank you.
No.
How do you think Alex would go? I know it's not a question, but I just thought I'd ask.
I think considering he's already received something from his mother and his financial state largely is a result of his own doing, considering that the father had some specific reasons why he didn't want to leave something to Alex, the court would still look to equalize the distributions from the two estates and give him something like $50,000 because the father's estate is worth $450 and the mother's was $150, so that the three children get around about the equal from total of the two estates.
Thank you. Anyone else want to share their thoughts?
I think he probably would get up, actually. I think that the deceased clearly knew from the statement that he made in his will that that Alex wasn't a man of substantial means, whether it's from his own fault. I mean, it says he has failed businesses, but also two failed marriages. The fact that at the date of death, that $150,000 was gone. He's got a minor child. He wasn't estranged from his father by any main fault of his own. I think he probably would get up, but the issue would be if he does truly, and this would be tested out at trial perhaps, or if it wasn't resolved at mediation, that if he truly does have a bad record of managing money, that it'd come down to the form the order takes rather than whether or not he would be successful or not. I think he'd get up, but you could line up all the judges of both the Supreme and District Courts and come up with a variety of answers to that. So
I think one of the problems with the form of the order here is there's not much money, is there? You know, it's not really worthwhile setting up structures for $50 or $100 or $1,000. So it's, you know, some of these questions are designed to be around smaller states where really your options are more limited and it's difficult.
Just bearing in mind it's Alex we're supposed to be advising, I would have thought his starting point would have been somewhere around about what he'd be asking for would quite easily and probably be about 300. I'm not aware that equalisation between children is a relevant issue in Queensland, so I wouldn't consider that at all. It's does he have a need? Do they have a competing need? To get him to a level where he's even about level with them with all of his things in the future, I wouldn't be surprised if he got 250, 300, depending on where the cost level are after. There may not be that much left after the cost, depending on how bitter it's been.
I just thought it was worthwhile going through that exercise because this is how you'll be thinking. You know, when you work through a question like that, you're going to be forming views because you're going to be considering all of those aspects of the matter. So it's worthwhile following through with, with your thoughts and where you're at on those issues.
because that's part of the assessment for you as accredited specialists. We've said earlier that there's the need to know the basics, but then there's that added level of value you add as a specialist to address these extra issues of how you would deal with it. So there'll be probably, bearing in mind as you answer the question, there's the need for you to be able to say what the law is and how the approach is, and then there'll probably be the opportunity to bring your experience to say, this is a way we may resolve it, and bring in the both legal and greater issues as to commerciality and the skill and ability that you can come about to raise a solution in difficult circumstances where the parties are quite at odds with one another.
So your insight, you're bringing your insight to the question, and that's really, as a specialist, what people will be paying you for.
Can I just ask a general question about the exam and the timing? So the exam, I think, what was it, the 29th of July. So the law that we're being tested on is a law as at the 29th of July. If there is, say, for example, a change to a practice direction, like a few weeks before that, will the exam be, and if there's a question on that, will that we'll have to answer obviously within the confines of the new practice direction, or is that how that's just an example?
Yes, that is the expectation.
Okay.
And there was, I think, an accreditation a few years ago where there was a very important decision came down 2 days before that changed things, and and it was, people were expected to have knowledge of it. Now, there may be a question that says otherwise. It might specifically say that you are to answer in accordance with the law as at this date. And so on those, you can be assured that that's what the expectation is.
On that, understand with cases and changes to practice directions, the one concern that I've discussed with a couple of people is if they bring in the new draft of the Trusts Act into Parliament, I don't imagine it would get passed in the next session, but that's the one that, because it is so markedly different and we won't know what's there based on the report at present, I just wanted to throw that out there that may be, it's too early, but that may be something that needs a bit of special consideration because it's so significant a change to everything from my last read of the Commission's report.
But I think, as you highlighted, Cliff, it's unlikely to be law by the 29th of July, so if it's not enacted, I would say you.
Now that you're of counsel, will you put that in writing for us?
He's not yet.
Sorry. Well, I'll wait 2 weeks.
I'm just protecting him because he's got no cover at the moment.
No, I paid my insurance premium. All right, are there any sort of general issues about any of the three items of assessment, technique or anything else? I reiterate, on the written exam, timing is crucial, and so because the reason I harp on that is because people said the same thing last time and people didn't answer all the questions because they ran out of time. So just be mindful of that and factor that in your planning when you're reading the question at the outset. I think it goes back. By the time these exams are attempted, they'll know how many questions and what the marking is. So that will give a little heads up as to your planning your time.
Yeah, I think that's right. We'll be closer to the time, things will be written, we'll know exactly how many questions there are, how many marks they're going to be worth, how long you're going to have, and all of that information will be given to you a couple of weeks before, so you'll know what your perusal time's going to look like, what your writing time's going to look like, what time reminders you'll get. So there's a big clock in the room, and it's really up to you to manage your own time, and you'll all be able to see it. But you'll get a warning probably at some point towards the end, just to give you a reminder in case you've lost track. So yeah, we'll be able to give you a lot of detail around that kind of thing, which can help you to have a bit of a plan in place before you get into the room.
Any other questions about, these questions generally, or anything else around the assessment? I thought I might just make one comment about the take-home assignment. We're harping on about managing your time in the exam for obvious reasons, because the time is very limited. Remember that with the take-home assignment as well. Don't chill and go, I've got 3 weeks, is it 3 weeks?
Plus 2, yeah.
3 weeks to deal with this, so, I don't really need to worry about it until I get 10 days in, because you will need those 3 weeks. So again, try and break up that time and make sure that you use that time wisely across those questions.
Just something that's been said in the last 2 sessions that I thought was really useful is when you think you're finished, plan your time with your take-home assignment so you finish a few days before you need to submit it, and then put it away. Don't look at it, try not to think about it for a period of time, maybe 24 hours, maybe a little longer, and then pull it out and look at it again, because you may bring fresh eyes to it and decide that you need to make some changes. And whatever works for you in proofreading, I can't proofread on a screen, I can only proofread on hard copy. I don't know if others, I guess it depends how you were educated and how long ago maybe, but whatever works for you in proofreading, it's really worth doing that as well, because particularly when you've really lived in a document for a while, there could be things in it that you don't notice or you just read over because you know where it's going. So, and those things are considered important, particularly when you've had some time to get it done. So I think it was someone here said make it something that you'd be happy to send out of your office.
And look at the question and what you're being asked to do. Is it write an advice that goes to the client, for instance? So bear in mind that it's being read by your client. It's not being read by an examiner on the Masters of Law exam who's testing you as an academic paper. So that's the balance you have to strike, perhaps, in answering that. In the take-home assignment, bearing in mind that there are marks for language and punctuation, syntax, all those sorts of things.
You are also given instructions about the expectations that you might not certainly put in a normal letter to a client, but whether the expectation is that you will quote law and cases in the draft. So you are given guidance on those points as well.
A lot of the feedback I've heard from other candidates over the year, otherwise being frightening, but I'm
scared when I hear that beginning of that sentence. Yes.
But most of the comments have been, don't underestimate the interview. And I was just wondering if you had any general advice, feedback, guidance in respect of the interview that you could share with us, please. Pretty please with cherries on top.
Probably very sound advice, I would think. Lots of people struggle with the interview because it is a bit weird, sitting in front of a camera, obviously. and you're obviously going to be a bit self-conscious about the whole scenario. But the interview is, from our perspective, is a very good assessment tool, because we actually see how you deal with things immediately, how you respond to a client who might be acting in a particular way, and how you are computing things, I suppose, and dealing with them in a logical order. And whilst it's to a degree artificial, because we have actors and you're in front of the camera, in reality, you have a client walk into your office completely, you often will have no idea what it's about, and you're sitting in front of them and you have to do exactly those things in front of the client. So it's not that far removed, in my view, from a lot of what we have to do in practice. It's just you've got the camera, obviously, which is a little bit foreign. So I think it's good advice insofar as people think, I do this every day. I'm chilled with that. But again, you're under a time pressure, so you're expected to be able to manage the issues, deal with them in a consistent way, and we do look at your soft skills. Are you dealing with your professional obligations? Have you addressed those issues? Have you really addressed the client's queries? And is your communication style appropriate? Depending upon what you're confronted with in that room. So those are all relevant elements to consider.
I just want to comment, when we did our assessment in 2002, I wanted to take on that point that Angela raised about acting in a certain way. So I had the interview with this person, and trying to get information from that person was like pulling teeth. And here I am, I'm sitting there and I'm thinking, this stupid actor hasn't learned her lines, right? And it didn't dawn on me that I was being presented deliberately with a client who was very uncomfortable in the situation, and we were trying to get information from her. So take on board that it's not necessarily the actor, it could very well be that
The
is
intention.
the intention.
Or the opposite, the client that doesn't shut up, and that's another thing. Again, testing your skills of controlling the client to get the information you want, bringing them back on track. And so you'll be let know beforehand what sort of information you are provided, whether you do get a situation where you've received communication from a client, you may have some information, or it's just there's an appointment made for you, and the first you see and hear from the client is when your interview starts. So you'll know beforehand what that situation is. Then there's the question of how you prepare yourself for interview. Some people have checklists and things like that, so that's perfectly okay for you to have a checklist. You'll know presumably that it's the, maybe it's an EA problem, maybe it's an EL problem, maybe it's an EP problem, maybe it's
you may not know.
Or you may not know. But so if you don't know, it's probably going to be in one of those three areas.
I think you can be fairly safe in that.
That's right. That's right. So you bring your truckload of checklists in, but no, so it's it's sort of, I suppose, just think through beforehand how you would conduct an interview for those particular areas. As I say, review your notes, and it'll be a question of settling the client down, covering your professional responsibilities, extracting information, discerning what the problem is, telling them what the problem is, and probably saying, well, the plan for resolving this problem is blah, blah, blah. And certain advice can be given now, it may mean you have to, the problem may mean, well, we have to have further interviews down the track, or I'll have to get advice on this, or what have you. But as long as you've addressed the issue of got the problem, you worked out what the problem is, and you've, in a competent way, dealt with that and come up with a plan for your advice to the client to deal with that issue.
You've got 40 minutes, I think, is what you normally...
It's in your hands.
Yeah, all right. Well, you'll have somewhere around that. It's hard. It's the hardest time to manage is the interview, because you don't... I guess you don't have that luxury of you know, checking where you're at on each issue, because you're trying to engage. And so that's probably one of the things that people really struggle with in the interviews. And if you don't get to the substantive issues, then you know that certainly is a problem.
And certainly it'll test your listening skills too, because that's one of the soft skills there. I remember when I did it the first time, I was so, I've got to say this, I've got to say this. I wish they'd shut up, and so I can get this out. But it's obviously a two-way process of listening to what's said and reacting appropriately.
I don't think the camera is, if you can pretend it's not there, that would be very helpful. And if you're really...
it's very large.
It is very large, and it's aimed right at you. It is aimed right at you, but if you can just try and get into the interview and focus on the person in front of you who won't be on the screen, I think that is a very good tip. If you can try and do that, just pretend it's not there and act how you would in an office.
So don't talk to it.
No.
And at the end, you are expected to do a file note. Again, you'll have a limited period of time, and you can either do a spoken file note to the camera, or you can do a handwritten file note. So you might actually want to think about that beforehand as to what you might prefer to do.
2 questions.
You can speak faster than you can write, generally. So.
If you choose the spoken, would you speak as in you were doing a dictation, like dictating a file note, as opposed to like talking to the camera and...
as if you were dictating your file note. You don't have to stop and...
Let's go back to that, Jenny.
I was actually just thinking that. If you are in the habit of making notes throughout a consultation, you know, whilst you're speaking, etc., is that appropriate, or would you prefer that you have the consultation fluid with your actor and make the file note if you prefer handwritten, if that's the case, at the end, or you don't mind as long as you make the most of the time?
It's really up to you. You know, if you like to make handwritten notes and then you feel like that's the best way is just to flesh those out when you're finished, then that's fine. Just be mindful of the time. I think 5 minutes is generally the time that you have. So just think about that.
Yeah, okay.
If you do know the topic and you bring a checklist in, I know we were told this, I don't know if it's changed, but it's also quite appropriate to provide your client with any information. So I had some fact sheets on different things which were my work, but that was part of my file note. So
Michelle, how come you remember so much about accreditation?
It's such a beautiful experience.
Yeah. Scarred by the memory.
She's so good with all the things that she's remembered.
it was just such a horrifying ordeal.
She still has nightmares.
Well, in fact, Michelle's gone back for two, so you know she's a dual accredited specialist, so it can't have been that bad.
No, succession was my passion.
Can I just say about the notes? As you're doing them, don't fall into the habit of, I guess, don't get too enmeshed in making them, because they're only for the purpose then of getting to the end and making your file note. So there'll be kind of different notes probably from the kind of notes that you'd make in a real file.
Yeah, because I mean, just sort of thinking, because I often jot things down whilst I'm in consultation, and then I'll make my file note when I get back to my office much more thoroughly, and that's just, I guess, my comfort zone, so to speak.
Yes.
But it allows me to make my file note much more comprehensive, particularly if it's a sensitive type of matter. So I wouldn't sort of, I wouldn't take the view necessarily that I would submit my scratch notes, so to speak, in throughout that I'd made through the consultation, but more using that as a basis of my proper file note. So in that respect, would that be okay or appropriate?
And I think, to be honest, Michelle, if you have a way of doing an interview, do it that way, because that's the way you'll feel most comfortable and natural.
Yeah.
So even if it's not something that you're going to use to convert into a file note, if that's the thing you like to do, by all means, do it.
Yeah. Okay. Thank you.
So exactly, if you elect that you'll speak to the camera or you'll speak your file note, if you're reading from your notes to get that across, and that's the way you create your file note. As you say, we're testing you on your sort of perhaps your dictation of your file note.
Any other questions at all?
So before each part of the assessment, I'm probably repeating what you said there, but you will know before you attempt the assessment what the conditions are, like how many questions and the time, what information you get prior to the client interview, and what the conditions are for your take-home assignment, font size and, margins and all down to that sort of level.
Yeah, the instructions for the take-home assignment come with the take-home assignment. Because you've obviously got a couple of weeks to process that, but the other information will come in advance.
But we can't stress time management enough. If you've got 3 weeks and maybe, I don't know whether it's 3 questions on the take-home assignment, maybe do 1 a week, that might be. It's a matter entirely for you how you arrange your time, but arrange your time so you're not running around at 4 o'clock trying to get a runner to bring get it in the mail, or a runner to bring the drive up here. Similarly with your written exam, you stressed that about 1 million times, so you just bear that in mind how you plan out answering your questions, and time will be a bit more difficult in the simulated client interview, because you've got a lot to get through in a comparatively short space of time. So I suppose it's just having your plan, and maybe your as I say, think beforehand. Well, if it's an interview on state litigation, well, envisage how you're going to answer that particular. Deal with your time, because you'll presumably know how much time is allocated, whether it's 40 minutes, 50 minutes, and what have you. So how you'll expect to start the interview, and how you tend to run through and get the information out, and listening to what's being said and reacting appropriately.
So final tip from me is you don't get lulled into a false sense of security when you get your written take-home test. You'll read it, you'll think, this is all familiar to me, I've got plenty of time. You need, and Angela has said it, Rob has said it, you need to start it immediately, and you need not to let it out of your sight until you finish it. So, because you will get lulled into this false sense of security, I've got plenty of time. you haven't.
You'll be living, breathing, sleeping succession law for a little while. So,
And then when you get to the end, you'll think, I haven't done enough. I wish I had another week, but you'll be fine. I hope you'll be fine.
We want all of you to get through, so but we want you to display that you have the qualities of an accredited specialist.
okay, thank you. Thank you everyone for attending and for being brave enough to put your hand up and put forward your thoughts. So thank you. And we wish you all the best.